Greetings everyone, I am Mabuto Nicholas Mabena. In the previous video we spoke about the ruling of the High Court in Pretoria, which dismissed the leave to appeal by the Minister of Home Affairs and the Department of Home Affairs against the ruling which was made, or judgment which was made in June, on the 20th of June 2023 with respect to ZEP. The court in June gave the minister 12 months to institute a consultation process to ZEP holders. That on its own does not suspend the cabinet decision that said it will discontinue with the Zimbabwe exemption permits. We need to clarify this. The judgment said the process was not fair, it was unconstitutional and invalid. It did not say cabinet has no right to discontinue with the Zimbabwe exemption permits. It did not direct cabinet through the Minister of Home Affairs to grant another version of special permits. As you know that in 2010 it was a documentation Zimbabwe project ZEP. In 2014 Zimbabwe special permits ZSP. Then in 2017 Zimbabwe exemption permit ZEP. So it did not direct cabinet to issue another version of special permits. Cabinet took a decision that it will discontinue with the special permits. Now what the court said was the process was not fair. When that decision was taken, the holders of the Zimbabwe exemption permits were not consulted on the impact the decision was going to make, or the impact the decision was going to have on the holders of the Zimbabwe exemption permits who have children who are school going. So it does not mean that the decision to terminate is suspended. The minister, in terms of the judgment, he has 12 months, what we do not know, because the 12 months was calculated on the day of judgment. But that consultation did not start because the minister said he was going to appeal. Now that the appeal has failed, we yet to get advice on when the 12 months will start. Will the 12 months start on the day of the judgment, that is on 20th of June 2023, or the 12 months will now start on the day the leave to appeal was dismissed? I'm sure lawyers in this platform will assist us on how these processes work. So having said that, this then gives, in our view, we might be wrong and want to be corrected, it gives holders of Zimbabwe exemption permits chance to continue to apply for waivers and to move to other visas. Because our understanding is that it did not suspend, the court judgment did not suspend the decision to discontinue with the Zimbabwe exemption permits. So it gives an opportunity, in our view, holders of the Zimbabwe exemption permits to apply to move to other visas. You'll recall that Helen Suzman Foundation went to court because the appeal by the minister was suspending the implementation of the judgment. So all of us were then afraid or worried that if by the 31st of December 2023 the appeal process is still in the courts, and the suspension of the judgment was in place, what was then going to happen post the 31st of December 2023? This is why Helen Suzman Foundation then went back to court to try and ask the courts to prevent any deportation of holders of the special permits beyond the 31st of December 2023. So it means that now that the judgment is operational, I haven't seen, as I record this, I haven't seen the statement from the Department of Home Affairs. It might be out there, but I haven't seen it. But now that the judgment is now operational because the leave to appeal has been dismissed, it therefore follows that the ZEP will not expire on the 31st of December 2023. Hence, we are saying it gives holders of ZEP time to apply to move to other visas, apply for waivers. We were asked this question in some platform on what this means. We do not see this as a victory ourselves for the holders of Zimbabwe exemption permits. We see this as a relief. There's a difference between a victory and a relief, because we are now getting to the middle of October. 28th of June, it's just around the corner. So it is a relief, not a victory. So it gives you time to put to get all your documentation that are needed and apply to move to other visas. Others, of course, who have moved to other visas are no longer affected by these processes because they are now out of the special permits. Some have received general work visas, some have received critical skills visas. They are now outside these special permits, and others are still trying to move outside these special permits, which of course was the decision of the cabinet. And we are saying, unless of course we are corrected and we are pointed out to be wrong, the High Court in Pretoria did not say cabinet has no right to terminate. Our understanding is that it did not, the process was not fair in terms of affording an opportunity to the holders of the Zimbabwe exemption permits. So the decision of the cabinet, as we understand, still stands in that the discontinuing of ZEP is still in place. We are on a grace period supported by the High Court judgment, which was saying its calculation was not sure because it had said, before the minister said it was going to appeal, it said 12 months from the date of the judgment in June. So we are not sure how the 12 months is calculated. And the challenge which we also have, which we'll discuss extensively in another video, is that because the sticker of the ZEP clearly says expired on the 31st of December 2021. We are continuing to have problems, particularly with the traffic department, which refuses to renew people's licenses on the basis that their permits are expired. We also have problems with the Department of Labor for those that are applying for UIF, because someone will be said, bring your permit, and when they look into the permit, the permit says expires. What we have liked to see, in our view, was that when Cabinet announced that it was going to discontinue with the ZEP or special permits, it should have provided, or it should have said, we will discontinue with these permits, but we'll give you a 3-year period to move to other visas. So in giving you a 3-year period, we give you a new sticker which will indicate that the permits will expire after 3 years. Because if you calculate the time the decision was taken by Cabinet in November 2021, by the time we exhaust the court processes, which in this case, if we stand by the High Court judgment, it will almost be 3 years since Cabinet took a decision. So had there been a 3-year grace period to say it's a notice, you have a new sticker, we will not discontinue after this 3-year period, you just have to go home. But this sticker allows you to remain legal in the Republic, allows you to access all services and to move to other visas. if that could have been done, it was going to make life easy for all of us. But as I'm saying, you go to some departments like Nedbank, we're having challenges with Nedbank. They simply look into your sticker and say your sticker is expired. Then now you are forced to then look for the judgment, to submit the judgment, and so forth. Please share your views in the comment section. Like this video, circulate. If you are on TikTok, please do follow us. Please subscribe to this.